The opinions you hear on Your Mountain from individual hosts or guests do not necessarily represent those of Your Mountain, our sponsors, or other entities we're affiliated with professionally or otherwise. You've waited long enough. Go listen to the show.
There are millions of acres of opportunity out there. They belong to you. Every day, decisions are being made that affect your land, your water, your wildlife. You should know about them. This is Your Mountain.
Hey everybody, and welcome back for another episode of the Your Mountain podcast. I'm your host, David Wilms. With me, your co-host, Nephi Cole.
Good morning, Dave.
Morning, Nephi. Small talk is going to be limited today. We're going to do a really quick hitter.
Go.
Big news today.
Big news. Go.
Big news.
Go.
We're going to do a quick hitter. I'm going to tell you what. We got this. Actually, a listener wrote in and said, hey, you should do a really short episode on what just happened in the U.S. Supreme Court involving the Utah case that y'all have talked about so much.
And what's crazy is, you know what happened, Dave? Nothing.
Well, what happened is kind of exactly what we thought would happen.
I know, but I'm just saying nothing because Utah would like for something to have happened of consequence, and instead the Supreme Court said, hey, Utah, just go home.
So in a one-sentence order, which is pretty standard, so don't read anything into this. In a one-sentence order, the Supreme Court today, we're on January 13th. Supreme Court today on January 13th issued this one-sentence order saying, Utah, your motion is denied. So they were asking the court to accept original jurisdiction and hear this case they filed. And the Supreme Court said, nah, we're not going to do that. That motion is denied. And the reason why we wanted to talk about this for just a few minutes is because, what does that mean? There are going to be folks out there. I've already seen some media reports. I've already seen some press releases saying, jumping up and down for joy saying, we did it. We won. Yeah, we won. Utah lost. Well, we kind of expected this outcome. Like this was the Hail Mary. This was the Utah Hail Mary. And we all know how often Hail Marys are successful in football. It's the kind of the same in the court. You run the Hail Mary hoping that you can bypass federal district court and that you can bypass the appellate court and go right to the Supreme Court to have your case heard. But it was always going to be an unlikely outcome. Does this mean that the Supreme Court will never hear the case, Nephi?
No, it just means that it's got a circuitous route to get there. It means if the Supreme Court is going to hear the case, that it's first got to start someplace else, and then somebody's going to win or lose, and somebody's going to appeal, and somebody's going to say, you guys should hear this again. And so there's just a number of hurdles. So if you're Utah and you want this to get to the Supreme Court, it's, there is no fast track to this anymore. It becomes like everything else that has to go to the Supreme Court. And that means job security.
It means this case will have to be filed in federal district court, probably in Utah. That's what I would fully expect to see happen next. I don't know. It could be days. It could be weeks. It could be months. It'll be on Utah's terms when they decide they want to file this case. They're going to have to make some changes to their complaint. Heck, they socialized this a little bit. Think about it this way. They filed this in August. It's a way of kind of socializing their complaint a little bit, allowed people to poke holes in it for, the better part of 5 months. And, now they can revamp their legal arguments a little bit, revamp their complaint a little bit, and approach this a slightly different way, potentially, if they choose to file this case in federal district court in Utah, which is what if you go back and listen to our earlier episodes, that's kind of where we've said this is headed, right? The likely outcome is that this ends up back in a federal district court somewhere and gets before the Supreme Court after going through normal course and procedure. So federal district court, appellate court, and then a petition again to the Supreme Court to hear the case. So that's really what's happened here. It's a big deal in that I think it would have been signaling. If the Supreme Court had accepted jurisdiction, it would have caused all of the hairs on the back of my neck to go up, right? Because I would have thought, oh, they think there's something here. There might be something to this thing, and they're accepting jurisdiction. And I might have been a little bit nervous. The fact that they denied it doesn't mean that they don't think there's something here, right?
Well, it just means that they want somebody else to take a look at this argument first. They're not going to take they're not going to, they only have so much time. The Supreme Court can't take everything, and that's frustrating to some folks because there are a lot of cases that are important to people, and the Supreme Court's it's not going to hear them all. there's a pyramid of courts, right? There's the highest courts in the land, but also, the idea is this workload needs to be shared. And this is one where the Supremes are like, this is not ready. This is not ripe for us. This is not ready for us yet. Now, when you said that, the hackles on the back of your neck kind of, sprung up, wasn't there a little piece of you that was just like disappointed because you had your 2 Supreme Court pens from your arguments out and you were just like sharpening them up, like, oh, like having been able to practice it, you were just hoping, like a child at Christmas time, you're like, maybe they'll call me. I'm like,
maybe I'll get back there.
I'm gonna fight this. No disappointment.
No disappointment whatsoever. I was very pleased with the order. It was the order I was hoping and expecting. And like I said, if the order had been, we accept jurisdiction, I actually at that point would have been a bit nervous. It would have made me really uncomfortable. At this point, they haven't really signaled anything at all. We're just going to have to go through normal process. If
they'd have taken it, it would have meant that somebody there really, really wanted it, right? I mean, and so that you would have had a justice there who, potentially you might say that, well, somebody's interested enough in this argument that they want to have it in front of the Supremes. They would have leaned on the rest of the justices like, no, we need to take this one. So the fact that it came out this short shows you that there wasn't that level of appetite in the court for having this argument.
I think that's probably right. I mean, you needed to have 4 justices say, we want to hear this. And maybe you had 2 that felt strongly about it and a couple others are like, I know you feel strongly, but we just can't go there right now. And I thought about this too. There are, one of the arguments Utah was making was that original jurisdiction applies when a state sues the federal government. And like, if that's part of the bar, like the states, there are 50 states and they sue the federal government all the time. There are a ton of lawsuits between states and the federal government. And it could create a messy situation and open the door for, okay, what does or doesn't warrant the court to accept its jurisdiction? I know there's still going to be cases where a state sues the federal government and it is going to automatically, the court is going to look at it and say, yeah, we need to take this case. It just felt a little messy and it felt like it could open a can of worms. And your point was right, Nephi. The Supreme Court accepts fewer than 1% of all the cases that are put before it, where people ask for the court to accept jurisdiction or to accept an appeal. Less than 1%. And they still have a big caseload, right? They're 9 people with a finite amount of time trying to deal with issues of importance for the entire country. And they have to be pretty selective in the cases that they take up. But this isn't the big point. The reason for doing this is we've been talking about it a lot. The news hit today. And to anybody that thinks, well, Supreme Court didn't take it, that means that's it. It's over. We're done. We're not having to deal with this issue anymore. Just say, I don't think that's going to be the case. And we're recorded saying this so you can hold us accountable. If we're wrong about that, if Utah says we're not going to pursue this in a different way. But remember, they appropriated about 20 million taxpayer dollars to run a public messaging campaign and a legal campaign, and it feels unlikely to me that their whole legal campaign ends on a Hail Mary. I think it starts on the Hail Mary, and then they go back to the chalkboard.
Yeah, I think the short answer to this, if you're wondering what's going to happen next, is coming to a courtroom near you, different courtroom. And so if you were getting all jazzed up and, it's, entities that were getting ready to fundraise on this, they're not going to not get to fundraise on this, because the reality is it's probably just going to, it's just going to be in a smaller courtroom, but there's still going to be legal fees. There's still going to be arguments. And, the question of, you're still going to have to pick good counsel. You're still going to have to, have strong arguments, because the other, question mark is, whatever happens there's going to, if this goes to another court, right? Just because that court's not the Supreme Court, when they come to a finding on this, that court, that finding has the weight of law. And the only thing that's going to happen then is somebody's going to, if you don't agree with that finding, you're going to have to appeal it up. But that lower court, when they say, when they drop the gavel and say this is the decision, the power of that decision is just as powerful as the Supreme Court. It's just that it hasn't been appealed yet. It's those judges, under the weight of the law, they can make judicial determinations at that federal court level just like they can at the Supreme Court. The only question is, are you going to like the decision? And then what are the appeal processes for you if you don't? So it's not like this is out of the woods.
No, it's absolutely not. And remember this, you all listening might live in a lot of different states, and maybe you're watching it and thinking, well, I'll keep watching what Utah's doing. Remember, Utah, they're sending delegations into other states. They're recruiting other states to join their effort. They had 13 additional states file amicus briefs in support of their effort before the Supreme Court. They're going to try and find support, potentially through amicus, maybe even through party status from other states to join if they decide to file in federal district court. So now's a great time, if you have relationships with your elected officials, now is a great time to lean on those relationships. Even if you don't have relationships, now's a good time to establish relationships and say, hey,
no,
we'd really appreciate it.
Yes.
Don't get involved in this.
Exactly.
Don't get involved in this when they come asking, say no.
Exactly.
Right? There's still things that you can do right now. Every single one of you listening that you can do right now.
Yeah, you can make the phone calls now. And now is probably the perfect time to start making the phone calls. Because what will happen, as Dave mentioned, that you had this group with other states on board going to the Supremes and saying, like, yeah, we'd really like you to hear this. Well, that same coalition doesn't exist yet for the case where it's going to show up. And so you want to call your elected officials in a nice way, right? And you want to let them know that let's not spend any, you don't want to spend let's not do this. And you want to tell them that because when this goes to court now, and Utah's going to be looking for, they're going to be looking for people that want to go with them. And I'm not telling you that you have to agree one way or the other. I'm just saying that if you have an opinion one way or the other and you want your elected official to fall on one side or the other, now's the time to make that call and to tell them where you think they should be on this issue.
No, that's exactly right. I had another thought, Nephi, and I totally lost it.
It happens to me all the time, Dave.
Man, I'm just getting to that age where thoughts leave my brain. But the point being, what states were doing before in supporting Utah before the U.S. Supreme Court might be different, a different calculus now, right? So if you were in a state where they filed an amicus brief in support of Utah, think about it this way. Utah was asking for permission to file a case that everybody knew was a long shot for the court to take. So it became easier for states to weigh in and say, yeah, accept jurisdiction, hear the case, knowing very well that it was very unlikely to succeed. And so there wasn't a ton of political consequence. It's different now, right? So now if Utah files a case in federal district court, there's a case. And it's going to follow the normal course of civil procedure. There's a case in controversy. And if a state joins, they're participants in active litigation at that point. And it's a different calculus. And so even if your state was involved in that coalition of states that supported Utah at the Supreme Court, they may be reticent to support Utah in federal district court. And they need to hear from you if you oppose what they're doing. That was the point I was going to make.
Good point, Dave. I know you got to go. You got other meetings.
I do.
And I do. And hey, everybody, thanks for being here.
Yeah. And if you like this shorter stuff, let us know. Maybe we can do a quick hitter every now and again on a breaking news topic. But this is the breaking news topic of the day. So thanks for giving us 10 or 15 minutes of your day and listen to this. You have comments, you have feedback. Here's proof that you send us an email. We listened. Somebody said, hey, you should do a quick hitter on this. Here we are. At least
Dave listened.
What was that?
At least Dave listens.
I try and influence Nephi. And sometimes I succeed, like today. So thanks, Nephi, for agreeing to do this on a short notice. Thanks to our listeners for writing in and saying, hey, you should do this. Thanks to everybody else for listening. Send us your feedback, yourmountain@itsyourmountain.com. And as always, remember, life is about experiences, so go have one.